any questions that you've got?
How quickly do those fines have to be paid?
Sorry.
How quickly do those fines have to be
They're payable immediately. So the judge has discretion.
Would normally have to be discharged within a maximum of 1 year. But for a company, you're talking about you wouldn't be given longer than 6 months maximum.
28 days.
Yeah.
But yes, I mean, obviously, part of considering the financial situation of the company is considering the time that's required to pay.
And the problem with a fine is it also comes with what's called a collection order, which means if you don't pay it, the bailiffs come round and can take goods to the value of it straight away. So it's a bit like what you would be familiar with civil matters. Actually, they don't need any further order. The order is made, and the moment you're in default of paying the fine,
I think the buggies would be first in line, wouldn't they?
Yeah.
Yes. Yeah, at the back.
I was just trying to pick up on your point at the end about the award of compensation. This isn't a case of tort breach of statutory duty.
No,
so how does that work?
What courts have done, usually when it's large companies, particularly supermarkets when there's been injuries to workers because of forklift trucks and things like that, the courts will ask if it's a civil claim. Now, the general rule of thumb is that a criminal court will not interfere with a civil court. However, when you've got a real disparity in power, Mr. and Mrs. employee on minimum wage or above, a large company, the courts will have no problem about awarding compensation. It will never be the total amount of compensation likely to be received in a civil court, but it basically turns around to the company and saying, stop delaying the civil, yeah? So say for speaking sakes, in civil damages, the person's going to get 40 grand. You might find a criminal court ordering £20,000, which ultimately will reduce the civil award, but making sure that that's paid up front to stop the corporations. What you do, you see, if you're a civil lawyer, is you say, oh, we won't admit liability, and we're not going to settle the civil claim, because there's criminal proceedings ongoing. So it can be 2 years down the line before there's any discussion about compensation. So it's the courts giving companies a kick up the bum, really, to start shelling out some money.
Yeah, the one thing is if there's a criminal conviction, then liability is unlikely to be an issue.
Yeah.
As soon as it hits the civil courts, it's just arguing about how much.
Yeah.
And that's just a factor.
Takes the burden off the small person, because they may not need lawyers then, because it's like, there you go, quick letter saying, please, how much?
And of course, in reality, the issue in a civil claim might be rather different, mightn't it? Because it's the question of the actual fault for the accident itself.
Yeah.
The liability pardon?
The company would have a bit of an uphill job.
Yeah. Yes. But it's not the breaches themselves, it's actually the causation of the accident. Yep.
In a case like this, would there ever be any risk of imprisonment, or is it just fines?
Well, bearing in mind the defendant is a company, you can't put a company in prison.
Yeah, you'd prosecute them both. You'd prosecute the company and the director. Imprisonment is fatalities and recidivists, people who have got a track record of these sort of things. The prisons are too full. But if it's serious, if there's a number of fatalities, or even one, and if it's high, then funny enough, the larger the company, the more difficult it is to send one of the directors to prison, because they have every right to turn around and delegate out. The people more likely to go to prison would be working in industries such as scaffolding. That's probably the one where high rate of risk, good potential for fatality, hands-on approach by the individual, probably breaching stuff in front of the office of the traffic commissioner, probably got overladen lorries, probably taking health and safety very, very lightly. It's those sort of small fly-by-night, well, I don't mean to be disrespectful to scaffolding, but I think they clearly are more higher risk of prosecutions and more higher risk of fatalities.
There was a case in Bristol, wasn't there, recently, which was it a hire company or something failing to maintain vehicles?
Lifts.
To a very high degree of culpability, and both the company director and one of the people responsible for maintaining the vehicles were sent to prison, they'd...
That was the bus which went down the hill and killed the individual. Killed the kid. Yeah.
I think the short answer is, it's on, I'd say that everything David said is right, but it's sod's law that if you want to play the game of, well, I'm likely to go to prison, you'll be the one that'll make an example of. So don't bank on that one. Yeah, not very nice.
All you need is a judge who's retiring that day. Because that's when judges actually go, well, hang on, I remember Clarkson, when he retired from Middlesex Guildhall, handed down 119 years to a burglar. He gave him 7 years on everything consecutive, knowing that it was his last day and he'd have to toddle off to the Court of Appeal. But
There's anything interesting on the Bristol case, which was actually typical, killed multiple mental health, including I think it's 6-year-old girl, around White House School. The driver of the lorry was found not guilty.
and quite rightly so, it seemed to be the right result because he was done for dangerous driving and there was nothing to do with his driving. It was a mechanical defect and the fact that the company who had been engaged in order to do the maintenance and keep the records of the maintenance were quite clearly liable criminally as well as civilly for it all.
The judge said it was gross negligence of the maintenance.
But they prosecute the driver to keep him in there because if they didn't prosecute the driver, the defence of the company would be, not us, it was the driver doing dangerous. And without him being in the dock, you couldn't get his evidence in. So in order for the Crown to show that it wasn't dangerous driving, it was a real defect with the vehicle, which was the real cause of it all, the prosecution kept the driver in. Like they normally prosecute husband and wife, small companies. They'll always prosecute both the husband and the wife if they're directors, on the basis try and force the husband normally, because who's more of the controlling mind of the company, or vice versa if it's the wife, the controlling mind of the company, to take a plea to allow their loved one, or their brother or their sister or whatever, to go free. And that's prosecutorial tactics.
Prosecutors will often, as I said, put multiple defendants in the same trial because it makes life bloody easy for prosecutors. Because if you have a series of multiple defendants, in this case, let's say you had the security firm, you had misuse, and you had our firm, yeah? It's a question of who's to blame, and two will blame the other one. So they all cross-blame each other. For the prosecution, they just say, somebody was injured, it's one of their fault. And they're so busy actually it's called a cutthroat defence, where you actually defend yourself by blaming another defendant. If that happens, chances are all three of them will lose. But the short answer makes prosecution very easy, because you just, instead of all three getting together and saying, no, nothing actually went wrong, they'll tend to fight each other rather than sort of defending the case. So it's a nice prosecuting tactic to keep as many people involved as possible.
You let them all cut their own throats.
Hi, I mentioned to you earlier that I'd been deposed on a US insurance case, which is a truly horrible experience, and you mentioned that this is being introduced into the UK
Highly likely,
laws.
yeah.
I just wonder whether you might want to explain a bit more detail for people that
Well, it's all about saving
haven't been
public money.
through that process.
They're shutting down courts. They're giving judges less money. They want to privatise the decision-making and processes. The way to do that is to cut down the need for courts. So what you'll find is it will be more American, that you may no longer ever have to give live evidence in front of a court. You're more likely to go to a law office, probably in 5 to 7 years, something like that, where your evidence will all be given there. And as you indicated, that it's actually just as scary as perhaps going to a courtroom. But yeah, it's just a way to reduce the length of trials, because courts are expensive to keep open.
It won't be long before you get your letter through post saying you've been charged, please ring this number. You'll ring it and it says, press 1 for guilty, press 2 for not guilty, press 3 guilty but not really, 4 for can we find a good barrister, 5 where's Mr. Campbell? It's a slightly worrying trend, but yes, it's something, it's going to be the next.
We're moving to increase digitalisation now in the court. So I actually work at the court firm, and we have computer issuing postal requisitions for low-level offences, and they're dealt with without going into a proper courtroom. They're dealt with by the civil magistrate in a back office, but that is only done with the consent of the defendant. I dare say, get something like this sentence in
With it being a criminal trial, 72,000 has been awarded. If the company doesn't have the assets to pay that, do they go after the director personally?
How long is this? Depends on the company setup, depends on the way the finance is done. This is a limited company, isn't it? So unlikely. So the director's assets, well, parts of the assets may be directly related to the company's bought them, such as company cars might be included, but no, wouldn't be the director's pure assets. The likelihood if they haven't got the assets, then they go into liquidation.
The general principle is that a company and the directors are two separate legal persons, so that the assets of a director aren't usually the assets of a director aren't usually available to the company to discharge its liabilities.
Which,
company accounts to be available to a sentencing court. So if a company was to refuse to furnish the court with their accounts, then the court can take a view that the company might be able to afford any fine that the court deems appropriate. So it's very risky not to take company accounts to a court hearing where there's a possible criminal conviction.
and the problem is, the smaller the company, the more risk they are. The smaller the company, the likelihood that it's linked to matrimonial home, because they've taken a loan out on the home. And the smaller the company, the less likely they sought professional advice about the basic systems they ought to have in place. And I'm not saying a cut and paste job, but there is clearly a market out there, just as there's many SMEs and small companies who may have lawyers on a retainer of, a nominal retainer, say 200 quid a month, to do with all their HR and all their employment, because they can't afford the bespoke service. There's clearly a market out there for the smaller enterprises to be able to avail themselves of this stuff. Because the problem you've got, you know, you want to say reasonable excuse, well, have you got any systems? No, I haven't. Why? I can't afford it. And the moment you employ someone, or even you subcontract out, and you've got no way, and that's the real problem. And we all know, history has shown us, that when governments bring in legislation, whether it be to take off proceeds of crime, or whether it be bribery, or you name it, the companies who the parliamentarians always say they're going after, the big drug dealers and all this sort of stuff, they're not the people who end up before the courts. It's Joe Schmo running a small business with 2 employees. And that's the real problem. Hopefully when you've got people who set up these businesses who work for larger companies, who've then been able to be open to a better health and safety culture, because that's where they did their apprenticeships. You know, it should be something part of the apprenticeship stuff, not just safety about how they're using lathes or automation. These are the skills we should be giving to young people in the future, which, I don't know, that's just a personal belief of mine. But
the other problem you've got is it's not just about assets and what it is. Remember the knock-on effect. How much work our events is going to get? You know, hopefully they've got some little customers that are going to stick with them.
And how much is their insurance premium going up by next year?
I mean, this is the thing that people often forget. I mean, it's slightly allied, but in different ways. You hear about people saying, oh, well, you know, you've got caught drink driving or something, and you think, yeah, how much does it cost you? £600 fine. And how much has your insurance gone up? How much is it going to cost you for taxes for a year and all the rest of it? And you say to people, why did you drink and drive? The short answer is you could have got a taxi. Even if the taxi cost you 500 quid, it's cheaper than actually taking the risk to get behind the wheel of a car. Now, I'm not suggesting anyone would do that, but I'm just saying there are other expenses that you don't always see. As David said, insurance, as you know, your name's going to be, you're the man who, you know, that drove a truck into somebody. You know, it's very difficult to bounce back. And while he's sitting here, what do you think his rivals are doing? Going around all his customers going, you said, do you? Ooh, gee, they're in court now, do you know?
Just a point of information there on the insurance aspect. Those underwriters have been sort of cultivated in recent years by people like myself to give good discounts if they can be demonstrated through the risk management and health and safety process in place. So before when the accident happens, get that done, then it's a cheap treatment as well.
I mean, I think it's one of those, it's interesting, and this is just a personal thought, but quite often I think you might find that those that have been through this process and have learnt from it will be a better risk than those that have never been through the process themselves. Because I can guarantee you that poor old Mr. Woodford, when he gets back, apart from kicking Mr. Roper right at the he's going to put into, everybody will be signing everything in triplicate and then some. You know, you get one of these buggies again is if you've got a license to fly planes in the interim. So, but it's an interesting. It's funny that people don't always look at that. It may be that yes, you look at a company and say you haven't learned the lessons, in which case you are doubly as liable because you should know better. But actually, some companies that have been through this process, it's worth saying to the insurers or whatever. But hang on. We've learned, look, this is how much we had 72,000 good reasons to learn, and they all came with a clean on it.
I had a job with the HSC. God, they were ball breaking. I had a small family firm, demolitions, and they were taking down a school. And matey boy who ran it, it was his dad's company originally. He took it over from his dad, and they were taking down this old school bit. And Dad had to come in because son had to go off somewhere, and Dad used to run the business. And son tells him what to do, and Dad thought he'd actually be really helpful to son and do a little bit more. And the roof just collapsed. And this is where you thank courts for, because yeah, he was guilty. The HSE, because it was a school and there was the new school next door, it was the worst thing since the Titanic and all this nonsense. And the court gave him a conditional discharge, because they could see Dad was distraught about what he put his son in, And son, with all the best of intentions, had to go off to do something and just told Dad, do this. And Dad went, oh, I'll help my son out. I'll just take this bit down. So courts are very good as a bulwark against arbitrary use of authority and power. Which the HSE, there's some very good HSE inspectors. But all you need is one or two whom for some reason, they don't like you, or they failed, and therefore they take it out. They found people to run the trains in Nazi Germany. There are people who have that outlook in life who are happy to do that. You're good if you've got good health and safety inspectors, but you know that there are some who just take a great delight, especially against someone who may be not the biggest company in the world. And courts are really good at saying to them, hey, we know your duty, but no further. So
just remember that, just pick up on that, it doesn't matter how small you are, it doesn't stop you coming to someone like me or David, employing us to take on board if you get into that fight situation. It doesn't matter, it's the size of the fight in the dog.
No, we're not here to town.
There we are.
Sorry.
Could I go back to the question of the distinction of the two legal entities of Mr. Woodford, or the director and the body corporate? If the unfortunate Mr. Boom had died, and there was a charge perhaps of manslaughter gross negligence, does then this flip back to him as an individual, as the controlling mind behind the company? He's personally responsible and has none of the protections of the shell of the company around him to say, wasn't my fault, my lad, all these other intervening factors got in the way. Does it flip then, depending on whether or not there's been a fatality?
Both of them, but, jointly and severally.
But I think a prosecution against him for manslaughter would depend on demonstrating what he personally had done wrong and what he personally, where he personally had failed. So simply because there were other failings, you'd have to actually look at what his individual failings were.
In this instance, most of the failings that we've identified is that jurors have been, he's not pointed as chief financial officer or sought to hand that failure to run MI events with anybody else. It's kind of hinged on his evidence as an individual that he's been charged as a company. And I just wonder, is there a significant difference in the outcome that we actually would seek to nail him as an individual, that defence of its
Yes, because imprisonment looms large. But the decision, the test to prosecute is two stages. One, evidential, and secondly, public interest. The public interest is always going to be high when there's a fatality. Because you have to ask yourself the question, if a person's running a business and someone's died as a result of it, should they be able to run the business in the first place? And there's a bit of a difference between an unfortunate accident where someone's fractured a hip and someone dying. So, and the problem is the guidelines for prosecutors and the matters which the HSC take into consideration, they're quite great, and it all depends upon the facts of the case. That's the thing. You used the example earlier about the tipper truck, and it was only when it came out about the real bad maintenance records of the company, that all of a sudden people who may have been following it on the periphery, they thought, bloody hell, it is the company, it's not the driver. And then when they realised it wasn't just the company, actually it was the director, because he was playing a part to ensure that there wasn't proper maintenance and that they were fast and loose with it. But then you'll get rail track, for speaking as you have a train accident, and although you want the money, there's not little point in sending a director of rail track to prison, because he or she will be able to show they're so far devolved away from the decision making on the ground that actually.
With due respect, it's not why we got the charge of doing that. It was, the directors of towns and tourism,
No, it's done for political reasons. That's why I said they always say they do it to get the big boys, the drug dealers, the big companies, but in the reality, that's not the people who end up before it, the courts. Or if they do, it's the fact that they can pace out so much money that actually they never go to prison. It's only taken, what now, recently, bankers are actually going to prison for what happened to us all 8 years ago. And these are only low down in the pecking order.
But I suppose if you go back to the question, what we've looked at today in a charge against the company hasn't in fact just looked at the failings of Mr. Woodford. It's looked at the responsibility of the company for his failings, but also that of Mr. Roper. Whereas if there were a charge against Mr. Woodford of personal responsibility, of personal manslaughter for gross negligence, you'd have to look at his responsibility. The company might be liable for manslaughter without him personally being liable. The company as a whole might be guilty of gross negligence without him as an individual being guilty. And so that would be the distinction.
The smaller you are, the more easier for them to link you with the actual harm or the gravamen of the criminality which they're trying. The larger you are, the easier it is for you to get away with it.
Well, it's difficult then to isolate the chain of responsibility.
Yeah.
What we're saying.
Hi, this is completely different tack really. How would this process work for cases against Crown bodies?
Crown immunity went back in 89, didn't it? Yeah, 89. It would all depend upon which Crown body it was. You've seen what's been put forward now in relation to MOD. Normally, if it's Crown bodies, the HSE normally what would happen is that there would be some sort of plea deal because nobody wins. Yeah? And the charges would be done differently. It's all different because what was easy in the 1980s to distinguish between the Crown and private sector. Now the whole idea of the Crown and the public sector is so muddled because of privatisations and subcontractors, etc. But no, I don't. I'm trying to think. Apart from MOD, who else? What do we own anymore?
Can I assist with that one at all? We still do have a lot of Crown bodies, so we're talking about government departments. The arm length companies that government creates to work as part of the government department, for example, non-departmental public bodies, they will be regarded as entities.
Yeah, private entities rather than Crown.
However, the government departments itself, which is still about 1 million people that work for them, Department for Education, Department for Health, Department of Ministry of Defence, you get the idea there are many, many of those departments. Those are still classed as Crown bodies. The HSC would still investigate because they would be the lead authority for whatever the government is up to, but they would be censured, so they would go through a humiliating process if they have done wrong, but the outcome would be where the senior officers of the companies would have to accept the censure, and then that would become publicised as it was done for the Ministry of Defence, but they would still have that Crown immunity. There is a bit of a public outcry to try and remove that, but there is an argument that still remains, and the argument is that if you do take the Crown to a prosecution, you end up taking money off the Crown and then giving it back to itself in the form of a fine. However, despite all that Crown immunity, there is nothing to stop any individual of a government department being prosecuted within their own rights for any gross negligence that they were involved in.
Well, it tends to be one extreme to the other. It's either a major inquiry that results in something other than a prosecution and dealt with in that way, or it's an individual right to the other extreme, which, as you've just said, could be brought in
My
their own right.
experience of this is I used to work for Public Health England, which was
You
an
have one
ombudsman
symptom.
body,
Oh, no, yeah.
until it was dequangoed by the previous government and put into the Department of Health and became Public Health England, which meant it then belonged to the Department of Health and therefore became a Crown body. Whereas, as it was Public Health Health Protection Agency, it was part of the NHS.
NHS, which is private entity.
Yeah.
Yeah.
So
Or that local
it
trust.
switched its allegiance, as it were. So I no longer work for that organisation. So I was just interested to see how it would pan out.
It's quite a wide topic, and I think we've touched. I hope you've got an answer there. I don't want to stop you, but it's one of those that how long we got, but it's there's quite a bit of factoring degree in that one.
Leicester Tigers only 6 points behind Exeter.
Is there an open forum? Sorry. Is there an open forum where these judgments can be viewed, or recent judgments?
Judgments?
No, I don't. I mean, there's cases are reported and written up in various reports, which we have access to.
You find them in trade magazines and things like that. That's probably the best way.
But there's no central point that
there's not a database. No, I don't know aware. Well,
the problem with the HSE website is that it only really ever talks about their successes, and only really shows many of the links to when they get home on stuff. The real measure of success is the investigations which go no further, and that's all about good practice. That's about looking to your trade bodies. That's about looking to other experts in the field, whether you've got a rugby stadium and talking to other people who have rugby stadiums. It's about developing your own good practice. And then hopefully it goes no further than once you've been interviewed. Because all the guidelines you can get are guidelines. They're not tram lines. But the best bit you can do is to follow them. But as early as we said about RIDOR, the new statutory guidelines are X. I still believe that if you're a reasonably sized company, you follow the old ones because it protects you more than the more lenient guidelines you've got now. And if you're doing it the old way, why should you pay to change your systems to do it less leniently? You know your businesses. You know how to run your business better than a health and safety inspector. You know better than any lawyer how to run your businesses and what the real risks are. And so that's, the law, so rely upon your judgment, but at least make a judgment. Where you get done is when you haven't even thought of making a judgment, or you've just ignored everything,
If you look at it from a claims perspective, because we're in the world of sport and entertainment insurance, and we do everything from motorsport, grassroots, through to Formula One, big events, any sort of size event, from a festival, sport garden festival, to your Glastonbury's of this world. If you looked at the actuarial information of struck by vehicle, it'd be in the top 10 of most frequent claims. It would also be in the top 10 of most expensive claims. Yeah. So, from my perspective, if you look at this prosecution for health and safety, and as a risk manager for sports and entertainment clients, when you see a risk assessment for vehicles in close proximity to pedestrians, these are significant risks, and we're expecting suitable and sufficient risk assessments that are recording the significant findings. And I would argue that if you do that job properly, you won't be here.
Well, so you won't be hit. I did like the fact that vehicles hitting pedestrians in Formula One. That could be quite serious. I can imagine that would be. I take your point. It's the reason why this has probably been done as this type of as a demonstration is because it is so common. But we could have picked other topics. But as I said, some people have said, well, what about? As I said, sort of in the actual trial itself, you could end up with huge bundles of documents. I mean, someone asked me outside, wouldn't you have got the contract between ourselves and the security company. Well, of course you would. Because if it was spelt out that what they should have done, they didn't do it, then you'd be going, look at that. Yeah, but I mean, how long would you, I mean, Paul Mesh and people writing these and Liz and others writing these documents up, you know, there comes a point you think, right, I've really got to go and see the children. So, or at some point.
Any other questions? Thank you all. So we leave it to Mesh to close up.
Thank you, guys. Thank you very much indeed for a really informative and enjoyable session. It's been, for me, a delegate here, it's been really quite informative. There's a few people here, there's 4 people in particular, probably didn't find it quite as enjoyable as I did. One of them being Chris, Lisa, Danny and Mohammed. So I'd like to say special thanks to them, if you could show your appreciation, because they've worked really hard today. Thank you. That's it, guys. Thank you very much for your attendance. Thank you very much for taking part and all your questions. Much appreciated. Have a safe journey home. And if you want to see things on the A.C.T website, have a look at that. And we'll be doing one of these again in the future, hopefully. Thank you.